This is Roger Scruton talking about common law in England and this famous case. I'm going to have to reload this and now it's going to clear that video. It's much better watching YouTube embedded on a web page for me, because then I don't get the advertisements. It's this bit at 15 minutes 42 seconds. Rylands v. Fletcher is an 1868 judgment upheld in the House of Lords from a judge who took common law to be something which was invented, was discovered from some more fundamental principle which is left as a it's defined axiomatically as a kind of undefined object, but what occurred to me was that the undefined object was the thing that Anselm wrote his so let's go and look at this blog post. I'm sorry that my blogs are so ridiculously complicated and difficult to follow, but this is the stuff that's in my head. It's what Hannah Arendt says at 1 hour 9 minutes 59 seconds.
To talk about thinking, it seems to me so presumptuous that I feel I owe you a justification. Some of you may remember that reporting the trial of Eichmann in Jerusalem, I spoke of the banality of evil, and meant with this no theory or doctrine, but something quite factual, a phenomenon, a datum of utter shallowness, where the uncontested evil of the deeds could not be traced to any deeper roots or motives. How monstrous and unthinkable the deeds were, the doer, at least one of them, and a very effective one, who now was on trial, was quite ordinary, commonplace, and neither demonic nor monstrous. In the absence of firm ideological convictions and also of specific evil or base motives, the only characteristic one could detect in his past as well as during the trial and in the preceding police examination was something entirely negative. It was not stupidity, it was thoughtlessness. Thinking is concerned with meaning and not with truth. And I believe that it was the error in many metaphysical statements to believe that the two are the same. And I think that in this respect Kant liberated us. He said that he would distinguish between intellect and reason and so on, and show the limitations of reason, of course, and knowledge and knowing, in order to make room for faith. I think this was an error. He fell into the old and not so very interesting apparent contradiction between faith and reason, which is very understandable for 18th century thought. What he actually did was to make room for thinking only. The trouble is nobody has solved himself. Nobody has helped, including Kant himself. Including Kant himself. That is number one. So I would indeed say, but of course if you quote that out of context, it sounds absolutely insane, that thinking is not concerned with truth and shouldn't. The second question. I would say reason in this Kantian sense is our faculty to think and to think beyond the limitations of knowledge, to think and knowing that we can never get knowledge and still not say that it's meaningless. See, if you would, for instance, say, a triangle laughs, that is not an untrue statement, that's a meaningless statement. Now take, for instance, the proof of the existence of God in Anselm of Canterbury, not in the later ones, in Anselm of Canterbury, you know. You will say, if you take this, as Anselm never does, as some way of knowledge, then of course Kant is right. It's simply untrue.
And Anselm's prologian. Faith Seeking Understanding, an address on God's existence, was written over the next 2 years between 1077 and 1078. 1077 is a significant date in the history of the Corporation of the City of London. It's 10 years after 1067. His single argument that needed nothing but itself alone for proof that would by itself be enough to show that God really exists is commonly taken to be merely the second chapter of the work. In it, Anselm reasoned that even atheists can imagine a greatest being having such attributes, but nothing greater could exist. And when I read that, I thought of Aristotle's description of God in the Metaphysics. So now we can go back to Roger Scruton at 1542.
Of my own about a particular hard case, which is the case of Rylance and Fletcher of 1865. A very well-known case in English law, which introduced perhaps the most important environmental provision that to date that our legal system had arrived at. The defendant was a mill owner who had constructed a reservoir on his land, and the water burst through old mine shafts into the mines of the plaintiff, which were thereby flooded and put out of use.
So, the question was he liable for the damage to the other person's mines? And the judge ruled that he was, because of a basic principle that he felt he'd discovered.
No similar case had come before the courts, because this was the new economy, the Industrial Revolution economy, in which everything was huge, threatening and uncontrolled. The court of, so there's a real question of who had the right to what and who was liable. And the Court of Exchequer Chamber gave judgment in the following words of Mr. Justice Blackburn: "We think that the true rule of law is that the person who for his own purposes brings on his lands and collects and keeps there anything likely to do mischief if it escapes, must keep it in at his peril, and if he does not do so, is prima facie answerable for all the damage which is the natural consequence of its escape." And this rule, the judge said, seems on principle just. But until Rylance and Fletcher, no such rule had ever been formulated. The fact.
So, I don't know where this is going, but it's about discovery. And when I was up at Harrow School There was some interesting things up there, but probably the more interesting of all of them was this, or the more telling. Oh, you can't zoom on bloggers thing. I don't think that's the important part. The important part is this. St. Anselm's Catholic Primary School. There you go. I think that's where you want to go to look for your answers. Ask the children.